So today we're going to discuss why the change in buyer agent compensation forced upon the realtor associations by the class action suits has changed everything about real estate in California. I know for the rest of the country too, but because I'm licensed here as a broker and attorney, we're talking about California, and I'm explaining this. The main audience is for attorneys who refer their clients to listing agents, because once and you hear this, you're going to have to change the way you do your practice. The good news is you're now, instead of wondering why you're getting paid $2,000 for a review and the listing agent's making $30,000 or $40,000 depending on the size, the amount, or the list price of the house you're referring out, why you're entitled to at least $6,000 to $10,000 for the work you're doing on every file. I've sold over 200 homes as a broker. California Association of Realtors has had me train realtors on multiple offers. They've had me train realtors back in the day how to negotiate short sales. So I know the work, and I'm going to show you and explain to you why the high value work that realtors can no longer do and has to be done by attorneys. I think it's worth more than half the file, but I think we can start with 6 to 10K, especially if you're referring out. There are methods that we used back in the day when I was helping people are getting allocations of foreclosures, and there were ways I set up one of them. There's ways to set up the practice so the people who have the business can get 50% or more of the listing agent fees, and they can do it legally without a violation of RESPA, without a violation of the state bar rules. But we'll talk about that in another webinar. For this one, this is the lowest hanging fruit. I think every time you refer out a file, we're going to show that the work you do is worth at least $10,000. It's a question of how much really you want to, of the listing agent commissions, you want to be paid back to you, and how you're going to go about it. And the reason why I'm picking 6 to 10 for now is because I want to help you and coach you on this. But eventually, you won't need me. Also, some of you, like I'm thinking of some of the attorneys who refer me work now, they've been doing this for 20, 30 years. As soon as they become aware of the important change today here about buyer agent comp, they can already do this. And that's really why I have a coaching program for some. This is just straight up education for attorneys. You need to know it. It's going to change the way you do business forever with realtors. And at the end of it, you might not even need me. I sure hope if you had work in San Diego and you're not from here, you'd refer your work to me. But that's okay. I really think that at the end of this, the California Association of Realtors, when enough lawyers learn this, and realtors understand the risks. Every file they allow a seller to pay buyer agent compensation, they've breached their fiduciary duty. I'm going to establish that today. They probably practiced law without a license, and they certainly saddled their sellers with risk for steering, compromising the fiduciary duty of the buyer's agent. And if you look at the forms and the whole process, probably commission fixing. Nothing's changed. The risk of class action suits, massive. The risks of a lawsuit after closing by a disgruntled buyer, let's say prices continue to are soft and fall down. I remember getting lots of calls from buyers trying to get some of their money back or get out of the deals. That's going to happen. That's a risk in down markets. In up markets, it's not a risk because they're like, all right, we'll take the property back and we'll sell it for $20,000, $50,000 more. But in a stable market or falling market, upset buyers are calling attorneys. So those are the risks right now. My program, this actually happens by way of education. But right now, I'm going to establish why attorneys are needed on the files. It's because of in part because of these seller liability traps, and in part because now that buyer agent compensation is part of a third-party contract and it's not the listing agent's money anymore, the listing agents aren't even licensed to do some of the work they're still doing. They're practicing law without a license and under the People v. Sipper case. This is, once you understand, here, let's just go to the Sipper case. Once you understand that in the past, I would go on a listing appointment, I'd say commissions are 6%. I'm going to share half my money with the buyer's agent. If they bring a buyer to the table, they'll get paid 2.5% or 3%, whatever we agreed to. But if I bring the buyer, I'll get paid the 6%. But it was my commissions that I was sharing with a buyer's agent. So of course, I had a right to negotiate it. Now, because of these class action suits, the buyer and the, let's see if I have it here. BRBC, yeah. The buyer and the buyer's agent signed this agreement, and here the buyer's agent, before they're allowed to see the property according to Realtor Association rules, that's not the law in California, but it's the Realtor rules, because the Realtor rules force the buyer to agree to compensate the buyer before they even see the property. The buyers are agreeing to pay 2.5 or 3%. The agents are being trained. Hey, you might as well go for the max. You're putting it in writing. There's no point in working for a discount. I mean, you can see the training on the internet. So they're going in for 2.5 or 3%. They're looking for like the max in the area, totally compromising the sellers. Because the seller that used to be concerned about buyer agent commission would, instead of paying 6% commission, might negotiate with the listing agent for 4%, and then it would be 2 and 2. But now you can pre-negotiate with the listing agent or even a discount agent, but the buyers and the buyer's agents are still going to come in at 2.5 or 3. And before they even see your property. So if you're getting offers from someone representing an agent, there's a 99 point something percent chance that agent will have checked this box and said, well, I'm going to get paid 2.5 or 3%. And don't worry, we'll get the seller to pay for it. And the buyer might say, well, that's a lot of money. Why would I want to pay you 2 or 3? Don't worry, the seller will pay it. Right? I mean, that's what's happening. High commissions are built into this process. So let me even just show you. So the buyer's agent checks this form and they write in the 3%. And now what is the seller or the listing agent going to do? How do they respond? Well, first of all, if you understand this part of the program, the DOJ and the class action lawsuits pointed out in the different lawsuits that when a seller offers buyer agent compensation and pays it, especially if it's a percentage, and that's what they almost always are, the seller risks compromising the fiduciary duty of the buyer's agent. I'd say in 2 ways. One, because by offering a percentage, you're incentivizing someone else's agent to have their seller pay more so they can earn their entire fee. So that's something that could be easily mitigated against, but listing agents aren't licensed to discuss it, explain it, or mitigate it unless they're attorneys. So that's one right there. I don't even see how you could argue against that. 2, as an attorney, think about this. This is like having the plaintiff pay for the defendant's attorney. I mean, could it be done? I don't know. Would there have to be just a ton of waivers and explanations and advice that you better get your own attorney going on? I think so. Like, how is this happening? It's stunning. So now, let's even think about how this happens. So, you're going to look at the RPA here, the purchase agreement that the realtors use. This is from the Realtor Association. I'm a real estate attorney and a broker and a member of the Realtor Association of NAR. No, I'm sorry, CAR, California Association of Realtors, which makes me members of NAR because I'm paying the money. They're asking for 3%. It's already been pre-written. That number should be, or you would expect it to be pre-written in here, although I could argue why it doesn't have to be anymore. Because, well, basically, the realtors were forced into this, but a licensee, someone who's licensed in California, doesn't have to abide by realtor rules, other than because the realtors say so. So, I mean, it's possible that what I'm saying isn't happening, but 99% of the time it's going to happen. Now, how does a listing agent respond to this request? Now, remember, CAR and NAR say these aren't concessions the way we're normally talking about concessions, and they can't have it characterized as a concession because then the lenders would have a problem, and because it would soak up almost all the room for concessions because it's such a large amount of money. So they've said it's not a concession in the normal way. It's kind of confusing the way they say it, but as an attorney, I think we know this is a third-party beneficiary. The buyer's agent is a third-party beneficiary of this purchase by the buyer, and they have a contract, and that buyer's asking you to pay their buyer's agent. I don't really see this being very different than someone having a car payment and saying, well, if I'm going to drive 45 minutes from my job to live in this house, I need you to pay off my car payment. I mean, could a realtor really be involved in that? Especially if they don't have any forms related to it. All the forms related to buyer agent compensation were removed by the Buyer Association because CAR because the DOJ said you've got to remove these forms. And the California Association of Realtors acknowledged they've removed all the forms. They don't have any forms in the database relating to buyer agent compensation. And I know because I searched the database, that's how I found this form. So the realtors listing agreement forms no longer provide for offers of cooperating broker compensation, which is how it used to be. We cooperated. We say, we'll pay you for bringing your buyer. So I'm going to share my commissions with you. It's not that anymore. It's a third-party kind of contract. So include any other forms that might facilitate such offers. So they have no other forms in the library of forms that facilitate such offers in the listing agent side. Buyers and sellers must separately negotiate compensation with their respective brokers as specified above. So right here, we're being told it's a separate contract for buyer agent compensation. So now it's in this checkbox. They're like a third-party beneficiary, and yet the listing agent has no forms to counter. They have no training to counter. They have no language to counter. There are massive risks if they counter. There are massive risks if they do nothing and just accept it, because now they're saddling the seller with liability for steering, compromising the fiduciary duty of the buyer's agent, and this practice that's keeping commissions very high. Like, how is this happening? It's probably happened about 200,000 times this year in California, because in the past, about 85% of these deals, 85 to 90 of these deals from the reports I saw, the one broker was paying commissions to another broker. Now, these post-closing lawsuits, maybe it's a little less, maybe it's now 80 to 85% of these deals. The listing agent is allowing allowing the seller to pay buyer agent commission. The seller didn't have that responsibility. They just engaged the listing agent to help them sell their house. They didn't engage that listing agent to say, I want you to help me sell the home. I want to be able to pay 2.5 or 3% that I don't really need to pay to the buyer's agent. And for so doing, I also want to be exposed to lawsuit risks, post-closing lawsuit risks, to class action risk, to disgruntled buyer risk. Like, they didn't ask for that, yet that's what happened because of these forms in this process. I mean, it's just stunning to me. I mean, I want to take it, I really want you to picture what's going on. This is why it's so frustrating to me. This is a counter offer. Now, this is just something, this isn't even my best work. I've spent many hours, and this is what I would work with you. I have in my membership area, I have 5 or 6 different forms and 6 different ways to respond. And I try to go over all the postures of buyer agent compensation and how to mitigate it almost, I'd say 100% to some mitigation. But it would start here. Box G3, that's the request for buyer agent box, is hereby unchecked. Any request for compensation of buyer's broker must be made in a separate written agreement between buyer and sellers and is not a term of this purchase contract. Because as an attorney, this is conflating keeping buyer agent compensation as part of this agreement in the counter. Like, that's causing a lot of extra negotiations and issues and things you have to explain. I mean, ideally, you'd bifurcate this process. You would say, okay, let's work on the terms of the house and the timing of the inspections and the closing dates, and let's keep that amenable. Like we can probably get there. We can probably arrive at a price. I mean, you cared enough about buying this home. We can probably get to a price that you want. Now, with respect to the buyer agent compensation, I don't have any problem paying buyer agent compensation. I'm speaking as a seller. If I get my price, but if I'm not going to get my price, why should I pay you as much? And as the buyer's getting a better deal, why would they want to pay you as much? And if you're going to stop this deal, that your buyer wants to do because you're not getting your full 3% and the buyer doesn't have extra cash to pay you, well, then you better take that up with your ethics people, because my understanding from the DRE website is that you have to put your buyer's interest above your own financial interests. That's on the DRE website. That's what a fiduciary does. So I want to separate that out. I want to make sure that everyone sees that the buyer and the seller came together. So I don't want to try to conflate this problem and have it all written in here by an agent who's I don't even see how an agent could draft any of this or anything useful legally. And I make that statement based on the controlling case in this area, a case the DRE cites in their circular dealing with practicing law without a license. And really, here's the holding from the people of VSIPR. Notice, this is people. Like this even, I don't blame you. I was looking at this for a month or two before it dawned on me what people, and I worked for a DA one summer. As you know, I prosecuted, that's the right word, about 20 preliminary hearings and a couple trials during a summer internship with a DA. And every one of those cases started with people. And it still took me a while to realize this is a criminal law case. When the unauthorized practice of law is criminal. I wasn't even thinking about that in the beginning. I was just like, how could realtors be doing this? I didn't realize, I mean, if you think about, like, I'm just going to say it. If it's criminal practice law without a license and plaintiff's attorneys go after realtors for every time they saddled their seller with exposure to steering, compromising the fiduciary duty of the buyer agent, or price fixing, I mean, like once you establish that it was criminal, well, I'm not even going to get into it. I think most of the attorneys know where I want to go, and I'm not here. I like realtors. I'm basically suggesting that they just work with attorneys every time they sell a home if they want to protect their sellers. If they want their sellers to have a chance to leverage buyer agent compensation and get multiple offers the way they used to, if they want their seller to sell for more and have a higher net and have a chance to actually negotiate properly, they need to bring an attorney in on the file. As an attorney who refers your clients to a listing agent, you can't, now that you can't unring this bell, as you might know, as you remember from evidence class. I mean, this bell's been rung. They can't do this. But let me just talk about how serious this is. If a defendant had only been called upon to perform and had only undertaken to perform the clerical service of filling in the blanks on a particular form, so they can fill in the blanks in accordance with information furnished to him by the parties, or had merely acted as a scrivener, again, just recording what the parties wanted, he would not have been guilty of practicing law without a license. But the record supports the conclusion that he went further. He determined for the parties the kind of legal document they should execute in order to effectuate that purpose. Well, when I'm telling you there should be two separate contracts, and a realtor chooses to write all of it in on one form, they are choosing how to respond. That is practicing law in my mind. Now, is it arguable? I'm not saying this is 100%. I don't need to say it's 100%. My point is that a realtor must inform their seller that there's risks of paying buyer agent compensation. And those risks can be mitigated against probably close to 100% if you bring an attorney in and they advise the seller. And it should be the seller's choice. Like, let's say someone's paying $100,000 over offer and the seller is going to take this money and move to a different country. Well, they might just not even worry about this. They might say, yeah, that's my right. I don't need to make them jump through hoops. If we close, I'm happy to pay them 3% and I'm ready to skedaddle. I mean, that's one scenario. Other scenario is, I don't even need this money. I want to sell this home because I don't want to take care of it anymore. But the last thing I want to do is worry about someone coming after me for the next 3 or 4 years. I mean, why would they even pay buyer agent compensation? Or if they did, why wouldn't they jump their mitigation measures up 100%? If they're willing to pay the 3% to keep the buyer's agent happy, why not do all the things that get you as close to 100% mitigation as possible? So we explain that to the seller and we let the seller make that decision. I mean, that's how we practice law. That's how we should practice real estate as fiduciaries of the seller, putting the seller's interests above our own as a realtor. You should have the professional intent and the desire for your clients to have the best result, to have full concierge service, to have the best service when selling their home. And they should be able to speak to an attorney, learn about the risks, mitigate them, and design their counters appropriately. For instance, you would educate the buyer and say, look, we'd rather not pay your buyer agent commission. I mean, we'd say 2 or 3%, but as a convenience to you, we're doing it. So we're going to ask you, for instance, to acknowledge, to deal with one of the class action suits, that the source of the funds for the buyer agent commission is coming out of your money. I was also an econ major. I know money's fungible. It's hard to say that in reality, but we know in the class action suits, they're saying, well, I didn't know it was coming from my money, the buyer agent commission. So we want them to acknowledge that it could be said they're paying their buyer agent. And then to really drive this home, my thought is I wouldn't do this all the time, but I would do it some of the time for a risk-averse seller. I'd say, and you understand that you could have sought a price reduction of 2.5% or 3%, but you're choosing to pay your buyer's agent, and you've asked us to do it, and we're doing it as a convenience to you, but you could have sought a lower price of 2.5% or 3% lower. Like if that's one of the risk mitigation measures. There's a host that we can talk about in other training. The point is, that's the point here. There's seller liability traps, and there's mitigation measures. Starting at 0 is another mitigation measure. If I provide that form for free. And if you, when you're signing up now, I'll give you, you can ask for the form and I'll make sure you get it. In fact, if you're seeing this on YouTube, I will monitor YouTube, and for the first 20 or 30 times, I will get the form to people or provide the link where you can get it. If you're seeing the same thing on Facebook. Now, I think we've explained enough here that the attorneys are now understanding that, I mean, if you really think this through, it's just stunning that a realtor association working for realtors who are going to represent sellers and buyers put a clause in there making it easy for the buyers to request payment, but the realtors have no forms to counter. I mean, they'd have to make up the language. They certainly don't have mitigation measures. They don't have the ability to bifurcate it, which would really help the seller in their net. And another absolutely killer thing is that one of the ways we get multiple offers is we would go to broker caravans and say, if we get an offer in the next 14 days or 30 days, we'll give you an extra 5%. We could broadcast offers to agents working with, say, relo buyers or the agents working with the strong buyers. We can identify them and talk to them and offer them more money because they're already, by the time they pay the referral fees and their broker, they're making nothing. When I've offered this on behalf of motivated sellers, I've gotten calls from the broker of the agent that was working with the buyer and asked me to restructure the way I worded my compensation offer before they signed the agreement. So he said, I need you to go up on the net and change this right now because the way you're doing it, he goes, and I know other relo people, you did it the right way. But for our relo company, we have to make this a bonus to the agent as opposed to however I worded it, because I want that agent to get paid. I don't want half of this going to the relo and a third going in national. I want her to get it. So could you restructure it that way? And then we'll sign the deal. So I went on the internet. I changed it. They signed the deal. House got sold. I mean, leveraging buyer agent compensation is an art. My friend Matt Jones, in other videos, and I'll make it available again, he wrote a whole book on it, and he gave anecdotal but strong data from his major farm, which was a subdivision near a military base, so it had tons of turnover and people knew the prices. And he showed by offering 4%, his clients had higher nets than the other people. And he talked about how this dawned on him. So I think it was selling his own property. It's a wonderful book. I leased it. I have the rights to it. I'll make it available for free if people want it. Maybe I'll do a video about it in the future. But leveraging buyer agent compensation is a way to help your seller sell for more. I mean, if you're going to be passive and agree to buyer agent compensation anyway, and you are, you might as well leverage it properly. Have an open house and say, buyer agents welcome and invited. We cooperate with buyer's agents. We're offering 3%. And if you're a seller, you understand that it's like an offer. You can state that without actually having to pay the 3%. They can negotiate against it. As I have videos on the net from 2025 explaining that when you do this well, we had multiple offers. We got about 9 offers. And as I we held our strongest on the side. And as we let the other buyers compete against each other, as the price got closer and closer to the fair market value of the property, all of a sudden the prices got there. And then when the prices got there and buyer agent commissions still were getting paid, I helped negotiate the buyer agent commissions down because the people wanted to buy the property. I was like, I don't know what to tell you. I can tell you, I can tell you this. And I would explain where we were with buyer agent compensation and how if they negotiated down, they'd be in the lead. I was licensed and authorized in writing to talk about it, so I could. A listing agent's not licensed or authorized to do that, in my legal opinion, and I will argue to the cows come home all the reasons why they're not. And it's all related to the fact it used to be their money and now it's not. And they're not lawyers. And I'd love to have that discussion. I'll have a webinar. We'll go up on, anybody wants to challenge me, we'll have a webinar on it. I'll prepare, and if you beat me, I'll come back. And we'll crystallize this issue. I don't mind being wrong on this. I just don't think I am. Now, and I'm saying that legally, and after checking the resources in any AI that was willing to go back and forth, and that's eventually conceded. But I will share that Grok goes back and forth on me. It'll concede, and then I'll go back, and it'll come back, and I go, well, why did you concede yesterday? And Grok goes, well, that's because today's version were arguing the industry standpoint, and they were supporting all the reasons, like they were making arguments like that case is old, or that the Realtor Association is doing this, so surely they're not wrong. And I'm like, that's like having the fox guard the hen house, whatever. Like, yeah, the lawyers at Carr are smart, and I've talked to them on the phone many times, but that doesn't mean that they aren't aware that listing agents are practicing law if they're filling out if they're writing in terms here. I mean, how can they not be? There's third party rights. There's changing of the positions of the parties. If a seller agrees to pay it, they now take on liability. If they do it on one form, it's very different than bifurcating the process into two, like it naturally should be. So, in my training and other videos, we'll talk about the exact counter language. This form and this form go together a lot, because it's sort of a forms-driven thing. The listing attorney would explain why the need to start at 0, explain the 4 positions, leveraging buyer agent compensation, passively accepting it, talking about it on the phone. Arguably it's 3. I broke it down into 4 ways. And then if they choose to leverage it, it's why not follow this method? There's the counter language. There would be 0. There would be that would be the max. But if you're paying, you can still mitigate virtually 100% if you follow one process. But not every seller would want to jump the buyer through those hoops. There's the different levels. Some of it is just buyer education, and then saying and still requesting it on this form. So it's our forms. I mean, it's all there. The point is, there's so much high value work for attorneys now that realtors can't do. I mean, how many realtors wouldn't like to be advertising and leveraging buyer agent compensation when their seller has a reason to go over fair market value now, like they've over improved their property on a flip, and they need smart, strong agents to bring their clients there and be incentivized to explain all this and hold them in on the deals because people are really getting a good value. I mean, we all know there's times buyer agent commissions makes a difference in the sale of the price. Some sellers would still be wanting, some listing agents would still want to do it the old way. Why not help them do it? Especially the smart ones who understand the value of sort of an auction process, a hybrid auction process. Not that it's binding, but having the buyers compete against each other. Some realtors used to do it. They were calling it buyer blitz weekends, and they were advertising, and you're leveraging buyer agent compensation and saying, hey, we'll pay you this much. A lot of top selling agents knew this program. I think many would like to go back to it. It's certainly an advantage for the agents that can do it. The counter language, back to it, right? There's 4 levels. There's protecting, and there's mitigating, and there's taking the market temperature. Like, in a market with multiple offers, I think you'd make the buyer jump through more hoops and give you more mitigation measures. So, those are up to the seller. It's a seller choice after education. Realtors cannot do that. Can you imagine them explaining what steering, how to mitigate the risks of steering? Especially the steering being caused by the very forms realtors are using and by the very act of having to pay buyer agent compensation. Wow. In the end, after enough attorneys understand this and start talking about it, I guarantee you, because Carr's still going to want to keep commissions high, Carr is going to have a form for their agents that says, you should speak with an attorney before you sign this agreement. Have them sign it, and then they'll have them sign the listing agreement. So at least the sellers will understand that what's in their best interest is to be able to mitigate the risk when offering buyer agent compensation. So now, this is where it's all interesting. I can tell you a few things from experience in the past, especially during short sale days. Lenders understood that attorneys were doing work, and they would have no problem with the attorney getting $2,000-$3,000, maybe sometimes a little more during short sale days. I would expect, though, some lenders might have a problem with $10,000 going to the attorney. Now, how you would structure this is the money would be coming. On the HUD, you'd expect it to go to the listing agent for their 2.5 or 3%. So let's say in $1 million home, $30,000 was going to the listing agent. The buyer agent commission would be a separate section of the closing document. And I'm talking about California. What many would call a HUD. Some of them might even call it a Plano. I don't even, there's different words for it, but it's a closing doc that escrow produces. And I'd like to see on that document the money that the attorneys earned by doing the work on there for $6,000 to $10,000. So this is where it is for the attorneys right now. You've understood the structure, and I'm saying between disclosures, contract review, and counter language mitigation, even if you're not calling up and negotiating with the buyer's agent, which I think could be important, that's $6,000 to $10,000 work right there. And you're done. I've just given you the difference. In the past, it was $2,000, and if more than more than that was going to the attorney. And I rightly feel that if you brought in the seller, you should be entitled. I mean, realtors spend a third of that money going to Zillow. Why not have it go to the attorney? There are times that lead producers will get 50%. Why not have it go to the attorney? They're producing the lead. Well, it would be an illegal kickback from RESPA. It would be a violation of the Bar Association rules in the past. It's not anymore because you're doing the work. And that's just this method. Now, I would also suggest you have a backup because the lender might have a problem with that or not. There must be another way for you to get paid fairly. My way is that I'm a listing broker. I can list a property anywhere in California, and then I could bring in a local agent, one that you might already know, one that I've referred to in the past, one in our network, or one that we hire using it's proprietary in that I'm not explaining it right now. It's just logical. It makes sense. I do it for family members when I'm helping them sell a home anywhere in the country. I mean, it's just not the time to discuss this. So my method's proprietary, but it's logical. And so we would get a listing agent. We'd talk to them about what we're doing and what they're going to do. And we'd say, so therefore, we're offering you 1%. Or we're offering you or I'd find out their normal commissions. I'd figure out what you were planning to do, the work the attorney would be willing to do, what I'm willing to get paid after talking to you about it, and whether you're in our coaching program or you're just calling me up and saying you need help. We'd figure all that out. We'd figure out what's left on the table. We'd ask the listing agent what their fee normally is, and we'd say, well, would you be willing to work for this? If we bring you the referral, we're doing all this work, and we're doing some of the counter offer and the negotiations. Basically, we're asking you to do marketing. We're asking you to put it on the MLS. We're asking you to field calls. And we want I don't want the people on their staff answering these calls. I want knowledgeable people understanding the process and who are able to protect their sellers properly. Like, this is a certified agent. We're bringing a certified agent in on the deal. Now, we can make sure you get paid that way too. That's our backup. And if I have to get paid less, well, if you're part of the pros and coaching program, that's fine. If you're just calling me up, we'll work it out. I'm a businessman. How much work am I going to be doing? If you're doing all the work and I'm not coaching you that much, awesome. Let's get it done. If I'm doing a lot of work and coaching you, I'd like to come closer to the numbers I like to hit. Like let's say somewhere between 0.5% and 1% on the files. Coaching members coach closer to 0.5%, and I'm negotiable. You do a lot of work, we can work that out. But I'm also going to tell you that when we've worked together for a while, we'll both see if we like each other. If we do, I will explain a system in which you're entitled to get even more money than that, and you don't have to become a broker. So to find out more, so what's the program? Wow, I did this all without, I had this wonderful thing all put together. I ran all my ideas through an AI. I said, can you put this into a modules for Gamma, and Gamma printed out all those cards, and I skipped it. But I know this is what I'm supposed to say. So now you know where you stand. If you're an attorney, you understand how to get paid $6,000 to $10,000. You know how to do that work. Awesome. I'm I'm actually fired up. I want you to do it. Now, if we can work together, please call. I'd love to help you sell homes in Southern California. And I happily, especially, like, realtors used to say, oh, would an attorney negotiate their fees with you? I don't negotiate. I'm like an attorney. As an attorney, especially if you had a medium or small practice, you negotiate your fees all the time. Let me say, I understand how hard and how much work and the kind of work it takes to get a good home selling client together, ready to go. I like that. I remember those soup commercials as a kid. An educated consumer is our best customer. An educated seller or buyer is our best customer. If you've educated this person into being a great seller, willing to work with us, understands our program, that's so valuable. I am more than happy to make sure you get paid what you feel you deserve. We just want to make sure it's compliant under RESPA, under the Bar Association. You're doing the work. I am happy to pay you. Ecstatic to pay you for doing the work. Honestly, you have no idea how much this resonates with me, because I've been on the other side and I've done the work and I've wanted to get paid more. So this is beautiful. This aligns with everything I believe. Attorneys get paid for doing attorney work. Realtors get paid for doing realtor work. So we're done. I hope you get paid a lot for the work that you do, which should be great. Now, if you want help, there's two ways to go about getting help. There would be getting help by just calling me on the phone or following them. You go to listingattorney.com, set up a consult, say, I've got clients, we're ready to go. I'd like to work with you, John, and we'll talk and we'll set up what our expectations for the sale of your client's home. This is nothing new to me. Like I said, as a broker, I sold 200 homes. And let me say 85 to 90% of those sales were me. Yes, Phil in my office has his own clients, family members, friends, and he's probably, let's say he's 15% of that. And then other realtors in my office bringing in their own clients. It was rare. Occasionally happened. I think we sold over 200 homes. 190 were probably my clients. I believe in educated seller. Like, I used to just sit during the short sales days in my office. I didn't hide anything. I gave everybody all the information. Sometimes they wound up hiring their brother or a friend to list the home. But again, a very large percentage of the time, people eventually did what they were doing and they came back. That takes work. I can do it for your seller directly. And then you can tell me what work you want to do and how much you want to get paid. And that's great. So if you want an experienced home seller who's going to use a system that can help your client experience the highest net and be protected, I think we're good. I think it's the ultimate level concierge service that you can offer. I believe in what we're doing that much. And I will talk to your sellers. And, if we need a listing contract that says they can get out of it at any time up until a contract. Once they sign the contract, they've got responsibilities. But before the contract's being signed, they can cancel at any time. I can work that out with you. If that works for you and your seller, it's awesome. I stand behind what we do. You can talk to me or Phil in my office at any time. And to me, it's just a question of how much work you want to do and how much work you want to get paid for. And you can run by things on me, on your files. It's fine. But I suspect there'll be other people that want the forms ahead of time, that want to have, we'll talk. If you pay me the $3,000 now, and this program's going to go up in the future, but for $3,000, and we'll make sure, like, this is just really a deposit against the fees. We're just doing the work ahead of time. When I get paid my listing fee, I'll refund this $3,000 if it happens within a year. Like, at some point, I just have to say, it's over for mental and accounting reasons. But like, if you're like, I don't anticipate anything for 2 years, we'll do it for 2 years then. We'll talk about, I'm not asking anyone to pay anything today. There's no, at the moment in this webinar, there's absolutely nothing for you to do. But if you want, you go to my website, you set up a consult, and we'll talk. And in fact, when I set up the AI to do it, the AI will be able to respond to you quickly. And if I'm not on the phone, the AI can introduce you to me right then. But otherwise, we'll set up a consultation and talk. Or you could just they say, John, I don't care if your AI wants to talk now. I can't do it till tomorrow. Well, that's what the counter's for. Now, So I anticipate that program being $3,000, and I will share the forms. We'll adapt my practice to your practice. I'll explain to you. I mean, there's so much that realtors do that don't make sense to lawyers. Like, that's what I'm here for, to explain. Like you're like, I want to cross all the I's and dot all the T's. And I'm like, and I'll explain, well, yeah, but that might blow up the deal. Or you'll see really odd things. Like, you'll see the buyer working to close, or the buyer's assistant working to close all the contingencies to protect the buyer. And the lawyer in you is like, do you realize you're cutting off, you're not doing a proper job for your buyer, because you might it's hard to forfeit. This is why I don't say it's malpractice, and actually feel it's my duty to warn them. Because in these forms, it's almost impossible to capture the deposit. It just creates a big fight. But they'll be closing down their buyer's outs and like getting upset that I'm not having my seller sign the forms fast enough. Or something like that. And I'll say, you just got to let it be. This is realtors. They want to get paid. Their broker says everything has to be signed. They don't even think. And like, you have to separate that out from what's really going on and important. And one of the ways, and a realtor who was a very smart guy during the short sale days said that he learned from his realtor buddies at his previous office that when discussing matter, like, some realtors are great. Like, they understand all this. I'm not saying all realtors are stupid. They understand all this. And he's like, yeah, I understand your point about fidelity to your client, John, and I understand your fidelity it was just in the context of short sales. And to his credit, he said, but there's also a fidelity to the deal. Deep down, the buyer wanted that house and still wants that house. They're just afraid. And the seller wants to sell, and they're just getting upset because the buyer is being a fool. And as a lawyer, you could get them out. But do you really want to get them out? Is it really in their interest to get them out? So it was phrased as there's fidelity to your client and fidelity to the deal. And I've always thought that that's a good operating principle. Like, what is the goal of my client? Is it still this? Fidelity to the deal, or the fidelity to your client's deal might be the way to say it. So there's things that will surprise you in real estate as an attorney, that I don't always think you want to use your best attorney concepts and focus them into a real estate deal. And if that offends you, well, we'll work together and we'll see it. And then we'll never get to like level 10 where we're working together and you're getting 50, 60% of the deal. Because I know when you get listing agents or other agents working for you in your office, unless they're like-minded, unless they're just like you, thinking like an attorney, it's going to be difficult. I'm not saying impossible. And I'm willing to adapt my behavior to work with you for the benefit of your seller, since you're the representative. But that's not how the industry works. And at some point, you have to understand what escrow is doing, what title's doing, why they're doing it. You have to understand, and this is where actually being an attorney is huge. You have to know that in that last week, many times those lenders get cold feet. I don't even know what's going on, why they can't get the funding in time. Maybe they're like, there's no one for the risk pool. They thought that there's no place to place this loan into whatever risk pool, and they screwed up approving it. And all of a sudden they act like they have quality checks. And they're saying, well, can you like go ahead and let this deal close, and we'll sign a lease and we'll help your buyer get paid. And outside your house will be the moving van and a pregnant wife, and they'll be crying and crying and crying. And your seller understands the issue, and they need a bad guy. And you're like, I'll be that bad guy. I'm going to get this deal done. But I'm going to say, look, I know you're getting pressure from your lender, Mr. Agent. Let me speak with your lender. I'll explain to that lender. They've already had you and your seller commit to this process. So much so that the pregnant wife is outside in front of the house crying, and my seller's wife is out there crying with her. I go, I can't imagine how much money you're going to get sued for if you don't fund this deal today, because my client's not going to do it. My client needs that money to move on with their life. They're not going to wait a month for you to pay. If you're blowing up this deal now, I'm going to make sure they're well counseled and they find a great attorney and they sue you. Like, there's times to be a lawyer like that. It happens I love escrow. I love title. Sometimes they stand in the way and you're like, I don't understand what's going on. And you do the research and you're well prepared and you're like, I'm sorry. I don't want to step on anyone's toes here, but I don't understand. And I'm sure I can work something out if you let me speak with legal. And they call back an hour later and say, we got it done. Right. So like there's times to be a lawyer and there's times to let realtors be realtors. And that's what my experience really over 20 years, 200 deals in my own office, but hundreds more clients that were advised. Like you start getting a feel for how to execute well in this environment that doesn't always make a lot of sense. So that's what this is about. Like I'm going to take my experience, and I'm not claiming I'm perfect. I marvel sometimes at how great some listing agents are at running their business. But all that I've observed, all that I've done, I'm going to try to help you become excellent at this aspect of it. And you'll be getting 6 to 10 on all the deals or more without me if you want to do it in Northern California and go with a listing agent and you want to be that attorney. I believe that after 5 or 10 deals together, you'll be there. Because after that, it's a lot. Once you get the experience and you've dealt with the issues and you see it, most of those issues repeat over and over. And I mean, we'll still be friends. Let's say an unusual thing comes up. You can call me. So we're good. So basically, in summary, if you want coaching that you'll get paid back on the first deal, that's $3,000. I've written to show you I've put this together. This structure shows you I've thought about it. What I've really done is taken my practice and I'll give it to you and it'll come out like this. Like this is the best way to sell a home. I'll explain that process to you. We'll have to get an agent on board. If it doesn't work, we default to the usual way realtors do things. This is going to be DOJ compliant. This is the best way. I've sold homes like this. This is a fantastic method. Doesn't always work. If there's not multiple offers, there's benefits to this, but it's not that much better than the regular realtor way. You'll explain this. Your seller's going to have to agree to really make this work to make unilateral broadcast of buyer agent compensation. Your seller should understand that mitigates the risks of inconsistent offers to groups that might feel that you offered someone else's agent more money than theirs. And, there's other ways to mitigate it, but making a unilateral broadcast is probably the best. It also could wind up in the highest net and the highest price, like all those things we discuss. You talk to me, then you talk to the seller, me talking to the seller, just like in my practice, I'll be talking to you. You talk to the seller, you got paid. Now, this was my second webinar like this. I'm sure it will get better every week. As it gets better, I hope to be able to charge a lot more money. I might not be able to, but I hope I can. So I think there's an opportunity. I have another bonus. If you sign up now, I'll just explain it. I pay the full value to go high level. I can give copies of what I've done out. They don't want you to give it away for free. If you're interested in this, because go high level, I use UpHeck for marketing. So let's say you're a divorce attorney and you wanted to try Facebook ads instead of paying someone else $1,500. You can design your ad and use UpHeck to put it up on Facebook and see how you do. You'll right there. That's a $1,500 savings. You can get an AI and UpHeck to do divorce attorney marketing on YouTube, where you'll see their theory of how this all works. You should be getting A+ ads. I've learned. Like this ad, if I'm bringing this to you, this is not, Facebook doesn't understand, YouTube doesn't understand it necessarily. It's hard to make this, but if you're doing cookie cutter ads, they'll give you the metrics you're supposed to hit. And if you're hitting them, you're like, that's the best you can do at those prices in your marketplace. And then you'll decide, can I afford to do this or not? And then it'll save you, I think, off a regular realtor or a regular advertising person. They might charge $1,500 or $3,000 just to get started. So that I can make available to you if you'd like. But then I just have to have you pay the $3,000 through my GHL website. And then, let's say that I would plan to have this rolled out for January. So the first 6 months of the year, you'll get it for free. And by then you'll know if it's working or So, you can talk to me about that. There's so many ways to work together. My name's John McConnin. I'm a broker and attorney in California. I really do, really the whole point is I hope every attorney, seller, and realtor realizes that to sell houses properly in California, you need an attorney on the team now. Thank you. Sellers, go to listingattorney.com, set up a consult. Me or a member of the team will talk to you directly. I'm always available. If you're saying, I want to speak with John, I'll speak with you. Realtors, I don't have a program set up yet, but if you take the initiative and you have some ideas how to help you, I want you to do the right thing. You want to do the right thing. You're calling me. We'll figure it out. In the future, hopefully I have realtors and attorneys everywhere that work together. Thank you. Listingattorney.com.